Good morning, everyone. Hopefully you can all hear me. Thank you for joining us today with Chris Dobbs, my colleague, and myself. We're going to be looking at the roundup of last year and also the year ahead. And I'm going to start looking at January last year. So, it's amazing this is over a year ago now. Obviously, we started off the very first day of last year with Brexit officially happening. So the transitional period had come to an end and we did officially leave the EU on that date. Unless you're looking at immigration matters, however, hasn't really changed a lot in employment law circles. The government have talked about obviously being able to deviate from what are European-based employment laws going forward, but at the moment, as you can probably imagine, they're quite busy with other things at the moment. Not a lot has happened, and so apart from immigration changing significantly, not a lot else has really happened on employment law to do with Brexit. Obviously, we know it's affected practical matters such as recruitment and such, but in terms of actual legal processes, it hasn't really changed. European Court of Justice judgments, although no longer binding, do still have persuasive effect. And in fact, I'm going to come on to it later, there was a case only yesterday in which is really looking at a European case. The other thing that happened last January, and we thought it was going to be the last one, but it wasn't, was there was a further extension of the coronavirus job retention scheme. As we know, this actually lasted right up until the end of September. But it has now been gone for 4 months. Thanks. And
it was just good to get all of that done.
Yeah,
and out of the way.
Yeah. Sorry, thank you. Sorry, I was going to say some a lot of noise there. Yeah, so the coronavirus job retention scheme finished in September. So hopefully you've all finished processing everything for that now. We were told there was quite a lot of fraud relating to it. But it's all gone quite quiet on that lately, so we shall have to see if any ramifications going forward. And then the main case in January last year was that of Gordon and JD Pierce. And this was basically a constructive unfair dismissal case that Mr. Gordon brought. And initially, well, in fact, he failed in the end anyway because of other matters. But a key point out of the case was that the employer argued he couldn't have been constructively dismissed because he basically reaffirmed any breach by engaging in their grievance procedure. And by doing that, therefore, he, in effect, accepted the breach and therefore he couldn't claim constructive unfair dismissal. He appealed, and as I say, he failed on other points, but the Employment Appeal Tribunal did say that the fact that he had engaged in a grievance procedure in itself didn't mean that he had accepted any breach. So he could have succeeded if it hadn't been for other things. So that was the key point there. And so for employers, that isn't something you can really argue going forward. If someone raises a grievance, then they've in effect left it too long to claim constructive unfair dismissal. They can still do so. That then takes us into February with probably the biggest case of the year, and that was our friends at Uber. This has been talked about many times over the last year, so I'm not going to spend too long on it. Hopefully you all know about it. You can always ask some questions. But this was obviously a landmark judgment because it went all the way up to the Supreme Court. In effect, Uber were trying to say that the lower courts had got it wrong by not placing enough emphasis on the contractual documentation. The Supreme Court, however, rubbished that and agreed with the lower courts and said, no, it's all the other factors, what happens in practice, for example, which is the key thing. They also said that in the practical sense, the way the drivers worked meant that they were workers. And so the key thing out of that was that they were able to claim holiday pay, national minimum wage as well as the main two things, as well as some other things as workers. But they were the two key things that they could claim. And we've seen many cases in the gig economy leading to these sort of judgments. And so going forward, and there was only one recently actually in a taxi arena on my taxi where it was held the other way. So it's not always the case. They're still fact specific, but Uber was the big one that really pointed the way for the gig economy to be shown mostly to be workers. Important one for you HR people was the second main case in February, and that was LA and Galen. And this was, Mr. LA was dismissed after less than 1 year, so he didn't have unfair dismissal rights. They said basically on his performance. However, he did raise race discrimination claims, particularly harassment by a fellow employee. Now, an internal investigation did find that the colleague had made racist comments to Mr. LA, and he was put through equality and diversity training. However, the training had been quite a long while before the comments were made, and there was also a case where another colleague talked about not knowing about the comments and etc. And ultimately, Mr. LA succeeded in his claim for discrimination at tribunal because they said that the training was too stale. There should have been refresher training, and because there hadn't been, despite the fact that the company appealed to the AT, it was held that the tribunal were entitled to come to the conclusion that the stale training in effect meant that Mr. LA succeeded with his race discrimination claim. And as I say, that's important for HR people, because obviously we know training is absolutely key, and I see it all the time with clients whereby they have lovely policies, they may even have had a lovely training program in place 5 years ago, but nothing's really happened since. If you do have the training in place, which obviously we would recommend you do, then you do need to refresh it on a regular basis. And then the final sort of few points in February, before I hand over to Chris for March, is mandatory vaccines. All been in the news hugely in the last few months, but it was about February last year where it really started gaining traction in the news about, at the time, talking about care homes having mandatory vaccines. As we know, they subsequently did, then the NHS was going to have it, and now within the last couple of days, it looks like a change in tact from the government. But who knows? I don't think that story is completely finished yet. There was also the issue of remote monitoring being brought up properly for the first time. Employees working from home were complaining that they were being monitored remotely by their employers in a way that basically breached their sort of human rights. This is something that's come over from America, keyboard, stroke, monitoring, camera monitoring, all that sort of stuff. Chris and I have talked about it before. We don't like it. We think you should performance manage in more sophisticated ways, which can still be done even when people are at home. But that was about the time that it was really sort of gaining traction in the news. And the third one, just a little thing on Moodbeam. For those of you who don't know, this was a wristband that tells your boss whether you're unhappy. I don't know if anyone has come across the actual wristband. Chris, have you, it's all gone quiet on that, so I don't know how successful. I did have a look before finishing my notes on this, and the website is still up, so they are still trying to sell it, but whether it's been successful or not, I don't know. Anyway, that's January and February. Quite a quick run through there because I'm conscious that we've got a lot to get through. I shall pass over to Chris for March.
Yep, cheers, Paul. And yeah, no, nothing on Moodbeam. I think there was probably an element of jumping on the mental health bandwagon with it at the time as well. Okay, so moving into sort of the spring of last year, and two big cases came out of the Supreme Court together, which I know had an impact on certainly some of our clients. Royal Mencap, as I say, was joined by the Shannon case to pose this overarching question to the Supreme Court of how are hours calculated for the purposes of national minimum wage, and in particular, how are sleep-in hours and on-call hours factored in. Slight difference in the legislation that they were dealing with. Mencap, the newer 2015 regs, Shannon, the slightly older 1999 regs, but the language in both is similar enough. It's fairly clear. And actually, for most of us watching this, the outcome at the Supreme Court was interesting, helpful, but not particularly surprising. I think it did come as a huge relief for the care sector, especially, that the Supreme Court concluded that sleep-in worker who is merely present is not treated as working for the purposes of minimum wage. Great news for particularly clients of ours in the care sector. And the reason for that is ultimately the legislation draws a pretty clear distinction between working and being available to work. It crops up later in some of these worker self-employed status cases as well. And the conclusion the Supreme Court reached here was that not only are workers not doing time work if they're asleep, but they're also not doing time work unless they're awake for the purposes of working. So that sort of ruled out the on-call hours as well. Separately, equal pay back in the headlines with the Asda case. So this was the question between store workers who were predominantly female and depot workers who were predominantly male but earned more money. It's been bubbling on for a long time now. The store workers argued that their work was comparable for the purposes of an equal pay claim. The key test in these claims at the stage that it's at, and this isn't the final test for this case at all really, is a question of common terms. And the Supreme Court here applied a really useful hypothetical test. If the workers were to move from one role to the other, would they remain on common, i.e. broadly similar terms? That's the basic question that's being asked. Oddly, the vast majority of prior equal pay claims have been public sector, where there's almost exclusively collective agreements, and therefore the answer to that question is quite easy. Yes, of course they would, because there's a collective agreement. Obviously not the case for Asda as a private employer who, as far as I'm aware, doesn't particularly recognise trade unions. And so the Supreme Court had to rely on evidence that those terms would, in fact, have been broadly similar. The Supreme Court agreed with the original tribunal and indeed every court all the way through, and found some 35,000 store workers had been on comparable terms to their depot colleagues. As I said at the start, though, this is not by any means the end of this case. It is still going to rumble on. It has gone all the way back to the tribunal at first instance to deal with the next stage, which is whether those two pieces of work are now of equal value. Asda are also running an overall defence that the difference in pay was due to a material factor. It'll be interesting to see what they mean by that, whether it works, and whether we end up in the Supreme Court 2 or 3 more times on this case before a final decision. Obviously, there are a huge number of other supermarkets currently involved in equal pay claims. So I think it's a case of watch this space at the moment. And that's pretty much it for March. It wasn't a particularly exciting month generally, apart from these 2 very big Supreme Court cases. So I will, if it lets me now, move into April. So April, big legislative change really was the extension of IR35 regime to the public sector. Not going to go into a huge amount of detail on this, firstly, because of course at that point it was only really relevant to the public sector. For those of you who it would apply to, if you missed it in April of last year, then you've got bigger things to worry about than me talking about it now. And thirdly, because it's not a particularly exciting topic. The IR35 regime was introduced to tackle this sort of faux contract to self-employed relationship for tax purposes, basically. The point to take away really is that there's now 2 very good reasons to be sure of the employment status of all staff, not only their employee rights, which we don't want to get wrong, but also the obligation on the public sector and of course now the larger and medium private sector to make that determination for tax purposes. Paul and I can discuss this in general terms if people want to talk to us individually about it, but ultimately online determination is being honoured by HMRC, and you may actually need to take tax or financial advice on it anyway. On the subject of employment status, another self-employed versus worker case in April coming from, I put the EAT there, but technically the decision I'm talking about is the Court of Appeal, and it's the Addison Lee case. So both the tribunal and the appeal tribunal had held that the drivers satisfied the test for Employment Rights Act, working time regs and national minimum wage, providing them all of the relevant entitlements to worker status. They also found in the Addison Lee case that for periods of time where drivers were logged into the app, they were also on work time. As I was mentioning back in MENCAP, they were available to work, therefore they're on the clock. While all of those judgments were decided back in 2018, the Court of Appeal had waited until after Uber was decided as to whether it would accept a further appeal on this case or not. It was declined in April, so that's why I'm mentioning it now, on the basis that the EAT had got it right following Uber. So yes, Addison Lee drivers were indeed workers. Finally, from April, it took about a year from the start of the pandemic, but we had a tribunal case related to COVID. Part one of our franchise of COVID cases, there's going to be several over the course of the next hour or so, was Rogers and Leeds Laser Cutting Limited. So what we find here is that Mr. Rogers' dismissal, well, he said he wouldn't return to work until after lockdown because he feared that he would infect his children with COVID, and was therefore running sort of our Section 44, Section 100 claims that really started to emerge during this time, these health and safety claims, and taking reasonable steps to avoid an imminent and serious workplace danger. Mr. Rogers wasn't able to establish that, and in this case the tribunal was perhaps unsurprisingly influenced by his actions, which included a breach of self-isolation guidance the day after he left work, and in contrast the fact that the employer had actually done at bare minimum all of the government regulated precautions, so hand washing, social distancing were all in place. Therefore, no, his dismissal wasn't automatically unfair. It was probably perfectly reasonable in the circumstances, and that was first COVID case went in the employer's favour. I think that's me done, actually. So I'll pass back to Paul very quickly.
Thanks, Chris. For now, you're back in a minute. So, yeah, on to May, and actually leading on from Chris's case just now, was a legislation change in May last year, and an important one, actually, particularly to do with health and safety cases. With COVID, obviously a huge thing. The government decides to extend protection from detriment in health and safety cases. So basically treating people sort of less favourably, really, but not necessarily dismissal for raising a health and safety matter. And this was extended to workers as well as employees. So it was quite a huge thing because obviously that allows workers from that point onwards to bring the same sort of claims as employees if they're saying that their employer has treated them badly due to raising a health and safety matter, which of course has become hugely more popular in the last couple of years due to COVID. The other sort of news in May last year was presenteeism and leaveism, all these isms, and this was based on a CIPD survey. Obviously, there had been a sharp increase in home working and perceived flexibility benefits due to the pandemic. But what this survey found was that more than 3/4, 77% to be exact, of employers observed presenteeism in their workforce. And this was basically meaning people continue to work despite being unwell. Okay, and that was for people working from home. Having said that, it was only slightly higher than those attending the workplace at 75%. So actually, presenteeism in the last couple of years has been a big issue. The survey, I think it was 668 professionals. Nearly 3 million employees were involved in the survey, and they found leaveism was also a problem. And leaveism is when you take annual leave when ill. And again, that was found 7 in 10 employers observed what the CIPD called unhealthy behaviour over the same period. So 70% of employers had seen their staff take holiday when unwell. And a further point in the survey was that whilst the CIPD accepted that more and more organisations were trying to do things to tackle this, still over 2/5, 43%, were not taking any action on presenteeism and 47% on leaveism. Enough of the isms now. But yeah, so nearly 50% actually of employers aren't really tackling that. I'm sure CIBT will continue to do surveys on this sort of thing. It'd be interesting to know if any of you have got any views on it. Not necessarily today, but if you'd like to let us know. Certainly, I've seen it. I don't know about Chris, but certainly seen stories of that happening. And then the theme of employment status being probably the biggest topic on, along with COVID in recent times for cases. There is the case of Somerville and the NMC in May, and this wasn't one on the gig economy, so slightly unusual. Mr. Somerville was a barrister, in the legal services, but he was appointed by the Nursing and Midwifery Council as a panel chair in 2012. And his appointment letter specifically said he wasn't an employee office holder of the NMC. It basically highlighted that he was an independent contractor. They weren't obliged to offer him a minimum number of days, and he was free to withdraw as he wished. However, he was required to provide his services personally, so he couldn't provide a substitute for probably obvious reasons. After all, he was the legal expert on the panel. It all went a bit pear-shaped, and he ultimately brought a claim against them for holiday pay on the basis that he was either an employee or a worker. Now, the tribunal did find that there wasn't sufficient what we call mutuality of obligations, i.e. control from the employer's side, and also obligations to provide work and Mr. Somerville to do the work, to be an employee. However, he was found to be a worker under section 233B, what we call Lim B workers, because it is subsection B of that section, and therefore his claim succeeded. The NMC appealed, but their appeal was dismissed, so he was found to be a worker. They basically said because he had to provide personal service, couldn't provide a substitute, and they did look at the Uber case as well, even though it was quite different in terms of facts, but overall he was found to be a worker. So this was another one in a long line of cases, albeit not in the gig economy this time, where someone was found to be a worker. And it really strikes home to me that the government really do need to do something about employment status. They keep saying they're going to, they keep doing consultations, but as of now, they still haven't done anything about it. On to June. Our friend Charlie Mullins. Hopefully probably all of you know who Charlie Mullins is. He is the founder, owner, leading shareholder, whatever you want to call it, of Pimlico Plumbing. And it's now, I'm going to mention the case I said literally was reported yesterday, because Mr. Mullins probably isn't a very happy chap today, because ultimately they lost their case on holiday pay, which they had previously won on one aspect anyway, that they lost on the worker status. But when it came to the holiday pay claim, it was held that because the leave had been taken, then there wasn't any holiday pay to be paid. But that was overturned, literally reported yesterday. Basically, and I said earlier about we still follow ECJ cases. That was King and Sash Windows was the case that they've now basically said that the lower courts got it wrong. And interestingly, OBIT, as we call it, which is sort of side comments, not legally binding, but they also said yesterday that the Bear Scotland decision, in which any break of 3 months in the series of holidays breaks the sort of deduction link, was decided wrongly. As I say, that's not an actual sort of decision yet. That's just a side comment made yesterday, or in the judgment, I should say. But they said they preferred the decision by the Northern Ireland courts that said that Bear Scotland was wrong. So watch this space, but it looks like the arguments on holiday pay are going to carry on. You then got another case. The reason I was bringing up Charlie Mullins was the fact about no jab, no job policies. So linking on to the mandatory vaccinations, obviously this is for those other sectors whereby there is no legislation being put in place, but nevertheless employers are saying that if you haven't been jabbed, then you can't remain in employment. Chris and I have talked about this before. I think Chris will agree with me that we don't necessarily think that's a good idea. Or certainly if you are going to have a policy, you need to have it in place that you can have exceptions, because obviously there are valid reasons why people don't have the jab, and to have just a general blanket no jab, no job policy is likely to get you into hot water around discrimination. So the other thing that month was the ACAS report on fire and rehire. Lots and lots of businesses through the pandemic have apparently been sort of dismissing and re-engaging on less favourable terms as far as employees are concerned, and there was some criticism of that. It has flared up in the news more recently again, and there's talk again about the government introducing legislation to curtail that, but again, as of now, that actually hasn't happened. So moving on to the first of the two main cases in June is for Statver and CGD Europe. This was basically where the EAT decided that gender critical beliefs are capable of protection under the Equality Act and the European Court of Human Rights. Oh, sorry, European Convention of Human Rights. So used to saying court. Basically, in this case, it was an overturning of the Employment Tribunal that found that the claimant's gender critical beliefs were not worthy of respect in a democratic society. So this is where the claimant basically was saying that biological aspects of gender are important, and was upsetting transgender, gender fluid people, and basically they brought a claim under this, saying that their belief was capable of being a protected characteristic under the Equality Act, and the EAT agreed with them. Now that's not to say that those people with those sort of views can just go around saying what they want and upsetting perhaps a transgender colleague, but the belief in itself is a protected characteristic. So if they are then discriminated based on that belief by their employer or in fact colleague, then they do potentially have a claim. So back in in the days of cases where we had sort of religion against sort of the contradiction between sexual orientation and religious sort of views, now we've got the sort of gender conflict as well. But essentially, you've got to follow a balanced line, and as long as there's no harassment going on by those people, then they are entitled to have those beliefs and they are protected. And then the second case, Chris said we've got many parts. This is part 2 in the COVID health and safety dismissal saga that's now filtering through the tribunals. Hopefully I'm saying this right. Mr. Akatatis worked for a company which basically dealt with PPE. So they sold and distributed PPE, and I don't know if you've seen in the government in the news today about the government writing off £8.7 billion worth of PPE. But anyway, that's just another point. But they, in this case, he basically accepted deliveries, entered details into the employer system, and sort of took photographs, promotional material of the PPE. As such, because he was working on that, he was classed as a key worker, and the business remained open right through the lockdown. In March and April 2020, he asked to work from home and to be placed on furlough because he was anxious about using public transport and working in the office. So essentially, he was making the classic sort of health and safety arguments that employees were making. He was denied because they said, obviously, the nature of his job, it was essential for him to be on site. He was given some options. He was told he could take paid holiday leave, or he could take unpaid leave for the period of time where he wished to stay at home. He declined that, tried to ask for furlough again, it was refused again, and ultimately he was dismissed. He hadn't been there for the 2 years to ask to claim unfair dismissal, but he did claim automatic unfair dismissal under Section 100 of the Employment Rights Act on the health and safety grounds. He was basically saying that the workplace was a serious imminent danger to him, and such that he'd been dismissed on that basis of asserting that, and therefore it was automatically unfair dismissal. However, this was 2-0 to the employers, following on Chris's part one. His claim was dismissed. The tribunal noted that the crisis was particularly in March, April. If you remember, that was obviously right at the beginning of the pandemic, and everything was moving quickly. Employers were having to literally think on their feet, and they were prepared to accept that even though Mr. Katates did have a reasonable belief in what he was saying, so he wasn't criticised particularly, but the employer, it was appropriate for them in the circumstances to expect him to be in work at that time, and his demands to be furloughed or work from home, which wasn't possible for the job he did anyway, didn't mean that he qualified for the automatic unfair dismissal. So he basically failed. So that was 2-0 to the employers, but I shall now pass you over to Chris for July.
Great, thanks, Bill. Before I move into the second half of the year, I'm just going to apologise for giving you a very difficult word to pronounce there, and I don't mean the second case. I mean the unnecessary V in Miss Forstater's name. For anyone taking notes, there's no V in there. That is a typo by me. I apologise.
Yeah,
Okay then, moving into July. The summer saw the government make moves to introduce apparently planned duty to prevent workplace sexual harassment. The Equalities Office had produced its report on the back of a public consultation, and the government response to this was, we will introduce a duty on employers to prevent sexual harassment. We will reintroduce protection for third-party harassment. And thirdly, we'll consider extending time limits for claims under the Equality Act from 3 to 6 months. None of those have happened. All we were told is that it would take place when legislative time allowed. The government has had other things to worry about, of course, consistently for the last year. Whenever legislative time allows tends to be government code for either when we feel like it, or in some cases we'll slip it into a budget. There's no indication of any immediate change of any of these. I can see maybe the 3 to 6 month one being slipped in another piece of legislation, but I haven't heard anything that suggests it will happen in the immediate or near future, so none to particularly worry about there. As Paul said, June, July time, we sort of saw this debate sparked around controversial fire and rehire practices. And as Paul said, this is ultimately a way of avoiding redundancies, pay cuts, by dismissing staff and re-engaging them on less beneficial terms. Again, as Paul had said, several high-profile companies gave this a go during the pandemic. CIPD, other HR organisations, most employee centres rights groups, a lot of employment lawyers, and indeed the opposition politically had all pushed for the practice to be outlawed. Government had to deny any plans to do so. It does sound as though there are now talks about that again, but again, it's not one of those things that's sort of on the front bench of the legislative debate, as it were, at the moment. So watch this space, what may happen there. For the time being, fire and rehire remains legal, but highly controversial, potentially dangerous, costly unfair dismissals, breach of contract claims, etc. if handled badly. I always say it's a last resort if you cannot find any other way to get the economic saving. That's basically what these are about, through any other means. Okay, case 3 then in our COVID saga, and it's probably the only big case that came out of July. Gibson and Lothian Leisure. This one went in the employee's favour, so 2-1 at stage 3. Mr. Gibson had raised concerns about Lothian Leisure's practices, and particularly his risk of contracting the virus or spreading it to his father, who was clinically vulnerable. Mr. Gibson was a chef in a restaurant run by the company, which, when it reopened, did so without any PPE or any other measures in place. Mr. Gibson, when he raised these concerns, was told to, and I quote, "shut up and get on with it," before being dismissed by text message without warning. Employment Tribunal, funnily enough, decided that Mr. Gibson had tried to take appropriate steps to protect his father by implementing at least those minimum government recommendations in what he believed were serious circumstances, imminent danger. The tribunal concluded that he did have a Section 100 claim and that therefore he'd been automatically unfairly dismissed. Funnily enough, in coming up with the judgment on remedy for this case, the tribunal discovered that the kind of employer who perhaps doesn't implement basic health and safety guidelines and on telling somebody to shut up and then dismiss them by text, had also been unlawfully deducting pension contributions and not paying them into a pension scheme. So that was added to the remedy in this case. Always a good warning to employers that other things will come out of the woodwork, I think, in employment tribunal claims. Moving into August then, we obviously did 2 sessions at the end of last year that looked at contemporary discrimination issues and talked about the menopause in some detail, particularly as a disability claim. I said then that I wouldn't talk through the cases in detail because there's excuse me, only about half a dozen of them, and they're quite easy to find and read yourselves. What I will do is talk about Daly and Optiva because it happened last year. And it is the case that I think kicked off the debate which got all of us talking about the menopause and menopause at work issues in the latter half of 21. So this is the case that made national press where the menopause symptoms were found to be capable of amounting to a disability. It wasn't a novel finding that had been ruled before, but as I say, it sparked this debate, possibly because of sort of social issues around women's rights in the workplace anyway, and women's rights more generally. What the tribunal did here was very carefully, and I think very cleverly, not say that the menopause itself is a disability. I think that would set too wide a precedent. But it did say that the combined effects of the symptoms can, when taken collectively, meet that test of being a substantial and long-term impairment. This isn't an opportunity to talk about the menopause and menopause workplace issues in detail, but needless to say, it started a national conversation on the topic. Menopause-related cases are on the increase. I've got one that I'm running at the moment that, in fact, is actually quite similar on its fact pattern to Daly, and I think it's certainly an area that employers have very little excuse to be ignoring now. Separately, we saw a useful indirect discrimination case back in August that related to maternity leave and flexible return from maternity leave. It was a very well publicised story. It made the front pages of almost every newspaper, I think, on the day after the judgment was released. Ms Thompson awarded about $185,000 after her employer, a small independent estate agent, refused flexible working request. Basically, all she wanted to do was move her working day end time from 6 p.m. to 5 p.m. So that she could get to her children's nursery by closing time. That was all she was asking for. It wasn't a particularly drastic change in most people's view, I don't think. It had been refused. The employer had provided business reasons, as you normally do in a statutory flexible working request refusal. But ultimately what the tribunal said here was the discriminatory impact more than outweighed the needs of the business to have Ms Thompson there for another hour. I think what this case really does is highlight the need to consider potential discriminatory impacts when deciding on statutory or indeed contractual flexible working requests. We all know a basic refusal where there's no potential discriminatory issue is quite easy to justify, but where these discrimination issues crop up, it is a lot easier for an employee to say that the decision was discriminatory in nature. Finally, I think for the summer, stage 4 of COVID, and I think the last COVID case on our list, unless you've got another one, Paul, I know I don't. This one was a little unusual in that the claimant had been granted leave to attend his sister's wedding in Italy. And during the time he was out there, Italy went into lockdown. Mr. Montanaro had taken a laptop and a work phone with him, was able to work remotely, and on discovering that he was going to be stuck in Italy, contacted work, said, "I'm stuck out here, what shall I do?" And he was told to wait, carry on with work, and await further instructions, basically. The day after that conversation, he was posted a dismissal letter to his London residential address. Funnily enough, he never got that, certainly not until he was back in London, and continued to work remotely with no idea that he'd technically been dismissed until he received his P45 by email on the 1st of April. Yeah, I would have assumed it was a joke as well. The tribunal considered all of the circumstances in March 2020 and the degree to which these created a reasonable belief of serious and imminent threat to health and safety, etc., section 100, and found that it was not inappropriate for the claimant to have remained in Italy, especially given he had to, rather than return to the UK. He was able to work, he was able to communicate with his employer and with clients from there, and therefore the dismissal not only didn't make sense because he could continue to do his job by some other means, but was also automatically unfair on health and safety grounds. And that brings me to the end of the summer. So Paul, back to you to bring us into winter.
Thanks, Chris. Well, we'll do autumn first, yeah. So thanks for that. Something that had happened right at the beginning of COVID and when the furlough scheme was brought into effect was, excuse me, the debate over whether employees could make people fairly redundant if there was the opportunity to put someone on furlough. So, you know, rather than put them on furlough, just make them redundant, or vice versa. What was the correct approach? What were the risks, consequences, etc.? And we were waiting for a case on this point, and finally one came through in September, and that was, and I always get the ones with the dodgy names, Mindurva, no, sorry, it's not dodgy name, just hard to pronounce, and Loving Angels Care. And it was a bit of a surprising result, this one, but it has been distinguished since, and there have been cases that have gone the other way. So in this case, Miss Mindurva worked as a care assistant, providing living care for an elderly woman. She did this until February 2020. Unfortunately, the lady then got too ill that she had to go into a care home. So in effect, there was now no job in relation to that lady. In May, Ms. Mindura asked for furlough. The employer refused Loving Angels on the basis that there basically wasn't any more living care work available. So once the lady had gone into care, there wasn't essentially any other redeployment opportunities in her living care area due to the restrictions imposed on the control by the spread of the virus. They then went through a redundancy process with her, and she was finally dismissed in July of that year. She brought various claims, one of which was the unfair dismissal claim. Now, the judge in this case actually held that her dismissal was unfair. And the reason he did that was that he said, essentially, Loving Angels should have, in July, considered furlough as an alternative to redundancy. So there basically was an alternative to redundancy in his eyes, and therefore, even though there wasn't any other work for Miss Mindura to do, so you would argue there was a classic redundancy situation, it was unfair to dismiss her at that point. They could have put her on furlough, waited to see, and then maybe down the line when the COVID situation had changed, there would have been a role for her ongoing. We were a bit surprised by that at the time. However, there have been, as I say, there have been cases since that distinguish it, mainly on the fact that an employer, if they can show they at least considered furlough, then if they went on to make redundancy, then that was deemed to be fair. So the problem for Loving Angels is they couldn't show any evidence that they'd even considered putting on furlough. They just flat right refused. Of course, this is a bit old news now. Now furlough has finished, but I'm sure we will still see some cases potentially trickling through, given the delays in the tribunal at the moment. We're probably going to see some more going on for another year or so. And who knows, some of them may be appealed as well. So watch this space on that. But it certainly was a live argument throughout the pandemic and why the furlough scheme was in place. Following on from the Thompson case that Chris was talking about, obviously that, as he said, that hit the news hugely, probably for the value of the award. But in September, with mental well-being obviously being a huge focus as we were going into the winter, I think the experience of 2020-2021's winter, where there was a huge increase in mental health issues for people across the country. It became a focus again, and the government announced that they were looking to make flexible working a day one right. So as you probably know, at the moment, you need 6 months in order to be able to formally request flexible working, and they were going to scrap that 6-month service requirement. But like it seems like a stuck record for Chris and I, it's not actually become law yet, and whether it will in the near future, who knows. I did do another check when I was getting ready for this in the last couple of days, and there's still, unless Chris can correct me, I can't see any sort of news on this actually becoming law now, despite the government's assertion that it would do, well, 4 or 5 months ago. Another case in September was that Gwynedd Council and Barrett. This was a Court of Appeal case, and basically the council decided to reorganise schools in their local area, which involved the closure of several primary schools. And this did include the one that Ms Barrett worked at. However, instead of applying a scoring matrix, which is often what Chris and I would be advising clients to do in redundancy, they decided to go down the other route, which was the application and interview process. So there's 2 main routes, as you probably know, when looking at which people to retain, and they decided to go down the application interview process. So she was effectively applying for her old job as a PE teacher, but in a new school. She was, of course, unsuccessful, and interestingly, the council didn't give her the right to appeal, and there were some problems with the consultation as well. She was made redundant and claimed unfair dismissal. The tribunal did find, because of the consultation problems, that the dismissal was unfair, but interestingly, and also that the right of appeal wasn't given as well. So for procedural reasons mainly, they said it was unfair. The council appealed, said that the tribunal was basically being too rigid in its decision. However, the EAT agreed with the tribunal and dismissed the council's appeal. She was applying essentially for the same job, and therefore it should have been more of a selection process. So they actually criticised the fact that they went for the application interview process. Chris and I would normally advise clients, if it is just a case of reducing down numbers, but people are still going to be doing the same role, then you should really always go through a selection matrix. It's only if the roles are fundamentally changing and you're sort of having new roles where perhaps the application and interview process is more applicable. So on that basis, the EAT found that the dismissal was to be unfair. Interestingly, they did say, and I don't know if any of you are on are linked to well-known barristers' blogs and publications and seminars, Daniel Barnett, but I know he is a fan of not having to do appeals for redundancies, whereas Chris and I, with respect, I think completely agree with him. We always think it's safer to do so. But in this case, the EAT did interestingly say that the lack of appeal in itself did not make it an unfair dismissal. It was for the other reasons. However, it was a factor, and it basically didn't help the council that they didn't run an appeal as well. And this is where I think Chris and I always think it's best to give an appeal, because it can rectify any potential mistakes that have been made earlier in the process. And if they had offered an appeal, then they may have been okay. On to October, Chris, please. So this case here, Smith and Teleperformance Limited, another important one for you HR people, in that it, as it says on the slide there, it shows the importance of a fair and thorough investigation. Mr. Smith was actually awarded more than £5,000, and this is a slight fun case in that he was dismissed for complaining about getting only 3 chicken nuggets for lunch. So the tribunal heard he was left shocked and disillusioned at the size of his £1.99 portion that he was handed in the office canteen. He queried why others were getting 4 or 5 nuggets, whereas he only got 3, and he said he felt antagonised when he was when he was told he had to pay an extra 99p to get more than 3 nuggets. Sounds ridiculous, but he ended up being suspended that day pending an investigation, which is probably where the employer started going wrong. Why you would suspend for that. However, their argument was that the canteen member of staff that he was dealing with said that he acted aggressively towards her, and that he forcefully pushed the box of food away and stormed off, leaving her stomach churning. So for that, he was suspended, and he was then sacked for gross misconduct. So they then said he acted violently. So we can probably see here they were on the back foot anyway. And DT agreed, basically finding in his favour. However, the reason this was kind of a reportable case is that they said the reason they found it was unfair and not in the band of reasonable responses was that a thorough investigation hadn't been concluded. So the take from this, I'm going to say slightly fun case, but probably wasn't for the company who had to pay out over £5,000 to Mr. Smith. A thorough investigation is key, even when it concerns chicken nuggets. So on that fun one, we'll move on to slightly more serious Follows and National Building Society. Miss Follows worked as a senior lending manager, but she was based from home due to having to care for her invalid mother. And she'd actually been doing it for 7 years, and the Nationwide had allowed that. She attended the office just a couple of days a week. However, on a restructure, Nationwide reduced the numbers of senior lending managers, and they decided that the remainder of those, of which Miss Follows was going to be one, must be based in the office. They said it was due to change in the nature of the work and the need to supervise staff on site. They did consult with Miss Follows, and she obviously said she couldn't do that for the caring responsibilities that she had. And unfortunately, because she couldn't come into the office, the Nationwide decided to dismiss her as redundant. Now, the reason this is an important case is she then went on to bring a discrimination claim based on being associated with her mother's disability. So she obviously had no disability herself, but because she was caring for her mother, she claimed that it was associated discrimination. And the tribunal agreed with her. They said that it was a relevant characteristic and that it counted to the fact that she was associated to it rather than being the person themselves with the disability. And because it wasn't direct, because the redundancy procedure in itself was what we would call a PCP, a provision, criterion or practice in the way they dealt with it, so it was indirect discrimination. This has opened up the possibility of future cases of what we call indirect associative discrimination. So watch this space, as we're probably going to see more of those sort of cases going forward. Right, over for the last couple of months, and also the important look ahead for Chris. So thanks, Chris.
Yep, thanks, Will. Right, end of the year then. So November, I will deal with the middle one here first because it's sort of already been and gone to an extent. Yeah, as Paul said, mandatory vaccines were announced much earlier in the year. Came into effect for the care sector on the 11th of November. Anybody working or volunteering in a care home after that date, unless exempt, would need to be vaccinated. We've covered that in our forum in updates last year. It's been covered by plenty of other commentators over the last few months. And I think in most cases internally, these situations are now resolved. It's far too early for any employment tribunal cases on it to have been decided, but I think our view generally was, providing that all suitable alternatives to dismissal had been considered by a care home operator, there's probably little grounds for a successful claim. Indirect discrimination is obviously going to be justified by the necessary compliance with legislation. Obviously, the thing to keep an eye on at the moment is the NHS position, which, as again Paul said earlier, looks very likely to be abandoned in the short term. Whether that remains up for debate into next year, this next year, I should say. Watch this space. Moving back to the top one there then, Sullivan and Berry Street seems to be one of those cases that's been bubbling on for a while, and we seem to talk about it every 6 months or so, or certainly every time something happens. This became a Court of Appeal case after Mr. Sullivan alleged disability discrimination due to his paranoid delusions. He was dismissed for conduct and performance reasons. So people who've been following this one or sort of vaguely remember it, this is the gentleman who believed he was being pursued by the Russian mafia. The original ET concluded that while he did suffer an adverse effect for, he had what was described as a mental breakdown basically for about 3 months or so, it at the time didn't look likely to last 12 months, and therefore he wasn't disabled. The question therefore ultimately is, given that the substantial effect lasted for those 3 months, what was the likelihood that it would reappear and continue, and therefore be deemed to be a sort of peak and flow type disability? The EAT agreed with the ET's conclusions, and so eventually did the Court of Appeal. The conclusion that you can't say on 3 months of experience that a condition will last 12 months was considered pretty well founded and rational. And I think the takeaway from this is it's easy to focus on the adverse effects side of the disability definition without always giving consideration to this 12-month requirement to satisfy the long-term aspect. It's a very useful question to pose very carefully to occupational health when assessing a return to work or need for adjustments, because if you're told that it's not going to last 12 months, the information you have there is that it may not be a disability. Moving on to the Keeble case, and another warning about handling internal procedures fairly. It's actually a less funny case than the chicken nuggets one, unfortunately. Mr. Keeble had worked for the London Borough of Hammersmith and Fulham for over 17 years. He was in environmental health. He attended a demonstration outside of work held by Jewish Voice for Labour, which the judgment described as socialist, anti-racist, anti-Zionist organisation of Jewish members of the Labour Party. During that demonstration, Mr. Keeble exchanged views with members from an opposing demonstration and was caught on camera making negative comments about Zionism, which he then shared on social media and went viral. This came to the attention of his employer and he was dismissed. The problem was that basically they hadn't put it to him first. And the reason for not doing so, the reason they said they'd move straight to dismissal, was that he wouldn't comply with any warnings. Employment Judge, I think it was Employment Judge Brown on this one, while deciding, sort of found that the dismissal and appeal officers were not influenced by political pressure, which was good, but the dismissal was nevertheless unfair because the comments were made with no link to his work in his private capacity, which is important for those of us who occasionally have to look at this situation of at what point is something within the scope of employment, or what impact does this have on us as an employer. He didn't actually personally publish any of the comments or know he was being recorded. The comments weren't discriminatory themselves, and he'd expressed his views in a lawful way, amongst several other issues that he'd taken with sort of the entire process and the procedure. And basically there was a complete failure to discuss alternative sanctions such as a warning. They had just gone straight to dismissal. Certainly for somebody on 17 years service. I think the takeaway from this being that any dismissal, especially as I say of a long-serving member of staff, absolutely needs a fair procedure. And indeed, as there seemed to be in this case, there shouldn't be a presumption of dismissal from the start. If your decision maker is influenced by that, then you need a new decision maker. And finally, moving into December, so first point to note there, we obviously had that temporary self-certification rule change that allowed people to self-certify sick for 28 days before they had to get a fit note. That's now reverted for any sickness since the 26th of January back to 7 days. But do be aware we've got the statutory sick pay rebate scheme now in place for SMEs. You might be able to reclaim 2 weeks worth of sick pay for anyone who's been required to take time off due to COVID. That's either having it or having to isolate due to a household member with it. The Burn and Holder Hay Children's NHS Trust case, not really interesting in its own right, but more interesting for comments that were made, as Paul said earlier, sort of obiter, off the cuff, as it were, comments. The question that the Court of Appeal was being asked here was whether or not there's a duty to disclose all the information by way of investigation documentation as part of a case, where the employee has a contractual right to it in the first place. It's a bit of a strange question, a bit of a procedural one. The conclusion, if you're interested, is that there isn't. But the more interesting comment was made by Lord Justice Underhill, who hints at a possible implied term of fairness in disciplinary procedures. And that, of course, would go above and beyond this sort of general reasonableness in terms of a dismissal that we impose by law, and also the general obligation by the ACAS Code of Practice. Obviously, if we say that there's an implied term, what he's potentially saying there is there's an implied contractual term of fairness, and that therefore the disciplinary procedure not being fair can give rise to a constructive dismissal claim. It'll be interesting to see how that one pans out. As I say, it's not necessarily one of these clear-cut answers, but it's certainly an argument, as it's come from the Court of Appeal, that I think claimant lawyers are increasingly going to use about disciplinary procedures. Okay, the last case, I know we've covered this in an update and I'm very conscious of time, so I'll just touch on this quickly. Hope and BMA at the EAT. Mr. Hope dismissed for refusing to stop making or to withdraw a series of complaints raised about his managers. He failed to cooperate in the investigation process when asked, and the chair of the grievance panel decided there was no basis for them and that they were vexatious. He actually initiated a disciplinary process against Mr. Hope, who was subsequently dismissed. Tribunal concluded that the reason for the dismissal was the claimant's conduct, based on basically the vexatious grievances, and that dismissal was within the reasonable range of responses available to the employer. The claimant had argued unsuccessfully that the tribunal had used the wrong legal test in this case, took it to the EAT, who in short said, no, the correct test is the one set out in law. The real question, quoting the EAT here, is and remains the statutory one, whether the employer acted reasonably or unreasonably. Ultimately, this is one of those claims where I think it was have a go, but he really had no hope, having been told several times that his actions were vexatious and amounted to gross misconduct. So that brings us to the end of the year case review and updates. I couldn't finish the year without picking out a couple of my favourite cases from the year. So firstly, I think we have to congratulate 14-year-old Hazel Cassidy and her mother, who successfully argued age discrimination. She was dismissed from her part-time waitressing job for being too young. Between them, they won the case and got £2,500 in compensation. And I think my award for sort of one of these headlines that looks a lot worse than it is perhaps, is the case of Mr. Rumbold, who was somehow unfairly dismissed despite being absent for over 800 work shifts. As a headline, you might assume that's 800 in close proximity. It was actually 800 over the course of his employment between 1999 and 2018. Although of course that's still about 40 a year. But the tribunal found that he had never been told his absences were a problem, he'd never been subject to any absence management process before his termination, and the procedure hadn't been followed. The first time that absence was identified by Jaguar Land Rover was supposed to be a warning. Second time recently that Jaguar Land Rover have been criticised for having policies that are unfollowed and unread. You think they'd have learnt their lesson after the non-binary trans identity Taylor case. But again, it's a theme we keep coming back to. If you've got policies in place, if training exists, keep them updated, make people read them, make sure they're being followed. Okay, 2022 and looking forward. Again, I'm going to try and race through these because, again, I'm a little bit conscious of time. But I'm also not going to take very long on these because they're basically the statutory changes that are pending. The figures that I've got there on the screen are the likely ones. They're still subject to a final vote and final clearance, but they're the versions I've been able to find on draft updates so far. Obviously, the middle one there, unless there's a major U-turn, doesn't look likely based on comments coming from the Prime Minister and Chancellor. Or indeed a change of government before April, you never know. We can still expect the NIC rise to go ahead in April. or the social care tax, as it's being called more accurately, I suppose. And finally, a few changes. I think a little bit of guesswork here, but the ones that are looking a bit likely. So yeah, COVID is still going to have a lasting effect, most notably hybrid home working models. Most of the tribunal cases are still to follow, but most things relating to COVID are, in terms of new claims, going to be out of time. So I think what we're just waiting for here is what happens with the live cases and those awaiting hearings. A couple of things that we'd mentioned over the course of the last hour or so had come out of the Good Work Plan. The only one that we didn't mention is this potential right to request a stable contract. The idea behind this one being irregular or 0 hours workers to be granted the right, presumably very similar to flexible working rules, for more rigid working patterns. Flexibility is currently considered very one-sided, especially for 0 hours workers, often to their detriment. So do keep an eye out for that one in respect to sort of formalised hours and more structured shift patterns. Unclear exactly what, but legislation on the cards to address unfair and unscrupulous tipping practices, obviously largely talking hospitality here. It relates to how tips are distributed. The idea, I think, is that it would outlaw this sort of generic service charge being added to your bill and held by the company, rather than being distributed to the staff correctly. And lastly, some form of carers leave entitlement. At the moment, obviously, most people who need care rely on dependent and often other forms of discretionary and unpaid leave. From what I've read on this, the intention is that it would be 1 week per year from day one for employees only. No indication that it will be paid at the moment, but obviously wouldn't stop an employer from allowing contractual pay for that time. They're sort of my top four. Paul, I don't know if you've got any 2022s that you think might have, you want to place a guess on?
No, we've obviously mentioned a lot of the key sort of consultation ones, like the flexible working day one, and you know, well, there's several things, but without getting political, I'm certainly nothing's going to happen in the next month or two. I don't think.
No, I wouldn't have thought so. Okay, I suppose any questions on anything we've covered? No, I can't see the chat, by the way, so I don't know.
There's nothing. No. Yeah, we've probably bombarded everyone with lots of stuff. Yeah. Chris is going to come on to a sort of bonus session, which a lot of people asked for, coming up in March, end of March, and I'll let him talk about it in a minute because he's done a lot of work on getting it sorted. But before I let him do that, just wanted to raise the issue of some more face-to-face sessions again. As some of you may know, we did do our August one last year when things had opened up a bit for a while, face-to-face. And a lot of people before then did say, oh yes, we'd love to come face-to-face. But actually numbers were quite low on the day. We've been talking, we are considering doing, obviously as we open up again into the spring and summer, more face-to-face sessions again. So it would be great if some of you could get back to us on that, if you would actually be interested in returning to face-to-face sessions, because we really need to. We'll have a look at the numbers. It may be that we'll do sort of more sort of lower number round table type sessions, as opposed to just the traditional talking to sort of 40 or so people in the way that we used to do it. But it really depends. We're more than happy to do that still, and do some sort of hybrid, using that word, of face-to-face and virtual ones going forward. I've just had a chat. Yes, thanks, Rosemary. Yeah, I agree. Rosemary's basically saying that it's hard for the presenter to do it on virtual and really made to value face-to-face sessions. I think Chris is in agreement with me. We both much prefer. I feel much more natural when I'm doing it face-to-face than staring at a screen. So apologies if I feel a bit stilted on it or come across a bit stilted, but nevertheless, I do know the advantages of virtual. Some questions coming in and some people making comments on face-to-face, that's great. Will the slides be sent across? Yes, slides and recording. The recording will actually, as far as I know, will be sent out to you after this as well. And obviously that will include everything. So is hybrid an option? Yes, as I say, we would probably carry on doing virtual events going forward, because some of our clients who are further afield can log on to them, but obviously we do want to return to some face-to-face ones. I'm seeing quite a lot of comments coming in. Thank you for those, saying they would like face-to-face. So we will look at that. And talking of events, I'll pass over to Chris to talk about the one in end of March.
Yep, excellent. Cheers, Bill. Yeah, so just to stick in there, obviously our next one is still date and subject to be confirmed, maybe in person. Realistically, it'll be, as per usual, second, third Wednesday in May, I would have thought.
It'll be in May, yeah.
Okay. An extra one at everybody's request. So this came out of the conversations we were having on discrimination, particularly disability, in the sessions towards the end of last year. A couple of people had mentioned getting someone from occupational health involved and coming to do a one-off session with us. And Anna's name there, as I've put on the bullet, third bullet there, was mentioned. So yeah, extra session on Wednesday the 30th of March. It will still be online, slightly different structure, panel discussion involving Paul, myself, Anna, who is the founder, director and clinical lead at WHIB, and Ezra McDonald there from Pump Court. He is an employment and commercial barrister. He's also a recently appointed employment judge. Hour and a half. Basically, we want to answer your questions. So the focus is going to be on the role of occupational health, the importance of employee well-being sort of throughout the employee life cycle. So any questions that you might have for any of the speakers on perhaps the use of occupational health in internal decision making, employee well-being policies and practices, or indeed how the tribunal sort of look at occupational health in disability claims. What I would suggest, if you send them to me in advance, basically, because what I'd like to do is have half a dozen questions perhaps prepared for the panelists, focus around sort of the big topics that people want answering, and then maybe have a slightly more open Q&A for the last sort of 15 or 20 minutes. So yeah, please do have a think, please do sign up as and when you get the invitation for it. And yes, if you've got particular questions, drop me an email, give me a call, let me know on LinkedIn, whatever the case may be.
Thanks, Chris. Yeah, I say Chris is putting a lot of work into this one. You know, he's managed to get Anna and Desra available. So it'd be great if as many of you can attend. And as I say, if you can provide some questions and that, it is going to be more of a panel interaction event. So obviously, the more people that take part and ask questions, etc., and put comments forward, I think the more useful it would be for everyone.
Absolutely.
So thanks, Chris, for sorting that out. If any of you need any more news, Jenny, who organises all these for us, she'll be obviously dealing with the administration side of setting that up. Yeah, it'd be great to see as many of you there as possible. Had one question in direct about long COVID, asking if there's been any cases on long COVID being a disability. There's been lots of it in the news, and Chris and I did talk about this in the discrimination session we were talking about, or Chris was talking about earlier last year. Obviously, long COVID can be a disability if it ticks the 12 months substantial adverse impact day-to-day activities definition. But I don't know there's any been tribunal cases yet, Chris.
No, I haven't seen a case.
No, I haven't seen any, which we're not surprised, because the tribunals are basically on a go slow at the moment for obvious reasons. Just to give you an example, I've actually put in an appeal on a case for a client beginning this week, and the Employment Appeal Tribunal works slightly differently, and they have what they call a sift by a judge. And all that is a very quick process normally, whereby they just look at the basic papers, they don't look at bundles or anything, and they just think, well, is this appeal got a possibility of succeeding? Otherwise, they reject it at that stage. When I spoke to the EAT clerk on Monday about this, they have a 6-month backlog just on that basic process. So that just gives you an example of how behind they are at the moment. And I know certainly Chris has put me hearing back in December, wasn't it, Chris? That's been months and months away, and it's only
yeah, a better way of looking at it is I've got 2 claims that were issued in about November, December time. I've just had preliminary hearings for them in the middle of August.
Yeah, so that's not even anywhere close to the final hearing. That's just a case management, isn't it? So yeah, there's a lot's going on. We've had some nice comments, encouraging comments, Chris, in the chat box. Now you can't see it, about the March event. So hopefully that would be a good one. Any final questions? Otherwise, yeah, it's gone 11:15 now. So we shall let you all go if there's nothing else. Chris has just kindly parked there. No other questions come in, so we'll let you go. Any more feedback on the face-to-face? We keep saying it, we would like to do them. We hopefully see as many of you in March and May as well, once we get that one organised. So have a great day, look after yourselves, and hopefully speak to a lot of you soon. Okay.
Thanks, everyone.
Thanks, everyone. Take care. Bye.